Never got off trail. He never got off on the
How conclusive,
the side.
though? Let's say they're the boots right there. How significant is it if you can match them up? I mean, do you think that's something that is, from your perspective, very persuasive if, in fact, you were able to match those boots up?
I think it certainly becomes more persuasive if you can match the boots up. I mean, it certainly would give some credence to the prosecution's version of what happened. I think the defense, at some point, has an obligation to dispute that notion by... But
they don't dispute that he was there at some point.
Absolutely. But the question is, we have a 45-minute window there between the time that the accident is believed to have occurred, which I believe was 12:45, and then the 1:30 a.m. where he shows up at Pimpleton's doorstep to use her phone. So what is the prosecution's contention as to what happened during that 45-minute period if Goodman supposedly went straight to the trailer? If that's where his footprints lead, was he pacing around for 42 minutes, or what was going on?
Staggering around. I wouldn't
staggering
say pacing.
around. I mean, do we see these boot steps, these footprints going around in circles, staggering?
Not in circles, no. But let's take a listen. We'll listen to the testimony. This is Robert Steffen, who is one of the investigators who took a look at this. Take a listen.
You did not look for any other footprints between that space and Mr. Campson's property, did you?
No. I didn't have any reason to look there.
You had, because you were concerned, you were convinced at that point that the entire incident or accident and investigation scene involved everything north of Miss Hamilton's driveway, all the way back to the accident scene. Is that right?
Correct. We were as part of our job to look and find all the evidence relevant. That's why we went on the other side of the driveway and the other side of the property to see if we could locate anything, and I was not able to do so.
I'm a simple guy, okay? I don't claim to be an investigator. I'm just a guy here on television, used to be a prosecutor, but I wasn't the one investigating these crime scenes. Meg Strickler, though, I mean, it's all being explained to a jury. I mean, I see myself as more of a juror here. Okay, we've got an accident scene, we've got boot prints, they lead to Lisa Pembleton's. Makes sense to me.
Well, no, actually.
Walks like a duck, staggers like a duck.
No, because it does not have a description, complete description of that duck. So I think there are some holes here, just like the investigator just said that's sitting beside you, that there's 45 minutes that are not spoken for, but the prosecution has not been able to delineate clearly what transpired, which helps the defense. Because remember, the defense does not need to put on a case here. They simply need to say, hey, this could happen, this could have happened, this could have happened. The prosecution simply have these footprints, but they're footprints. They're not literal marks as to what he did for those 45 minutes. And as a defense attorney, we can blow a lot of big holes in that part of this case.
Janet walks like a drunk, staggers like a drunk. Is it a drunk?
Well, he was impaired at one point, and he was zigzagging, and I think we're all going to agree. And, we keep calling these police officers investigators. They're police officers. They're not looking for a reasonable hypothesis of innocence. They're looking, like the cop said, for evidence of guilt. I mean, he's trying to prove that he went directly to the house from the crime scene, and the evidence does not substantiate that. I don't think that footprint is the smoking gun, because he did go to the door. He's not saying he didn't. And I didn't find that testimony very convincing when he said, I went maybe some 100 yards beyond. I went a little bit beyond. That did not sound like a thorough investigation. I think it sounded like someone who had already come to a conclusion about what happened. That's not an investigation.
Well, and here's the advantage that the defense has, Charles, all the time, is that they don't have to investigate anything. They just have to come up with something, right? Come up with something. So they come up with, he went to the barn and got drunk and then came back, rather than, following actual footprints from the actual scene to the star witness's home.
Well, I mean, if I recall, there was also a witness, perhaps a couple that lived next door, that recalled hearing some kind of banging that was going on. And that would indicate that perhaps, Goodman was stumbling around in the night trying to get into this barn, where he ultimately wound up, consuming all sorts of quantities of alcohol. But no, I think that reasonably the defense has to investigate that claim. I mean, when you sit down with a client, you go through the chronology, you try to get a recall from your client as to what occurred, and then you follow through and attempt to establish through witnesses, through documentary evidence, et cetera, your client's movement in this case. And so I don't think that it's necessarily just a story. I mean, this is obviously what Goodman told his attorneys, and so that's what they're going with as far as the argument.
Yeah, and I think that the real issue that they have is doesn't make common sense, right? The whole premise of the thing is that I got into a fatal crash and then I got drunk. Right? So that's the premise of the story. And then the story is, well, those boot prints that go straight to Lisa Pemberton's, no. I went somewhere else where the boot prints don't lead to.
Investigators followed a distinctive set of footprints to the entrance to this farm where the footprints stopped. They soon found their key witness, Lisa Pemberton, living in a trailer back there at approximately the location where that trailer is now. Pemberton told them that at about 1:30 in the morning, Goodman barged into her trailer, woke her up, and asked her if he could use her phone. But he didn't call 911 for another 25 minutes, which means by the time he called, it was an hour after the crash. But Goodman says that he first went to his polo player Chris Campson's barn located over there. And on the second floor, in what Campson calls his man cave, Goodman found some liquor. And after drinking the booze, which explains why his blood alcohol content was elevated a few hours later at the hospital, he then made his way over to Pemberton's trailer.
So does that story make sense? Let me bring back in my guests. We've got Meg Strickler, we've got Janet Johnson, and investigator extraordinaire Charles Mittelstadt with me. And let me go to the ladies first. And Meg, with a straight face, okay? With a straight face, can you tell me that story makes sense? And let me show you the map again, okay? And then we'll see if you can do it with a straight face. Let's take another look at that map if we can. Put it up there. Don't forget that much closer to, walks past Pemberton's trailer, then to the cave, right? And then to the trailer. So backtracking. Does that make sense to you? Can you tell me that with a straight face, Meg?
Yes, I can. Here's my attempt. What I think may have happened is he's in a very serious accident with 48 mile an hour or 63 mile an hour impact. That has clouded his judgment, forget the alcohol, and as a result, he's staggering around. And so he's not thinking straight. He's just heading to whatever he can see on a dark night in order to get to a house, and then decides to go to the other place after he has soothed his pain. How's that work for you?
All right. Well, Janet, would you be concerned if that's the story you've got to take to the jury?
No, because you don't have to refute the state story. And what the jury is going to be told is if you think both sides are reasonable, it's not speculative. There's going to be evidence that he went there. He's going to have to say he went there. The two people that live in the area are going to say, we heard noises. And this is his friend's man cave. I mean, he didn't go there to get help. He went there to get a drink. I mean, I think that's going to be his story. If that's reasonable, even if the state's version is reasonable, that's reasonable doubt, where both sides have a reasonable story. And I think it's a really good defense, and I could sell that easily to a jury and basically say, you could believe what the state says, but if you also believe that what my client says is reasonable, that's not guilty.
All right, Charles, let me play amateur investigator here, right? Goodman has the meeting. I'm there. I'm the investigator. I'm there with Goodman's lawyer, and he's telling me the story of what he did. Wouldn't you immediately get over to that barn, get over to Campson's barn and find whatever he was drinking out of, because you could swab that for DNA, right? If you're taking a drink out of a bottle or a cup or however you're swigging his stuff, you could swab that and get Goodman's DNA, and you could prove to that jury that that's where he was drinking.
Well, I don't know that we'd go so far as to, to try to get some DNA samples.
You would try, wouldn't you?
No,
you
you would
listen, don't
certainly
forget,
verify
your
the story.
client has unlimited access to unlimited funds, okay?
But he
Bottomless
also,
pit, like free refills.
But he also has no burden. And having said that, I mean, it's clear that we have no burden here.
Right.
However, it is a somewhat ambiguous story, and I do think that it would behoove the attorneys in this case to at least on cross-examination establish what Goodman drinks, what his drink of choice is, and then with Campson on cross establish that he had that particular liquor in his man cave, to at least kind of connect the dots somewhat. I mean, they need to seize upon the fact that this so-called footprint investigation was inadequate. It's being conducted by a police officer. It's not being conducted by detectives. It's not being, there's no foot cast being taken, shoe cast. By the officer's own admission, he's not going to the man cave and looking around. I mean, it's an inadequate, incomplete investigation. And so, while the burden shifting shouldn't occur in this case, there are ways to score points on what we have to work with here without assuming that burden.
Meg, the object of the game for the defense is to walk the client out of the courtroom a free person. If he comes in your office and tells you, no, I was drinking at the man cave, I'd lock down that man cave and I'd be swabbing anything and I'd find that evidence there, wouldn't you?
No, actually, I wouldn't. I'm not sure what I would do. No, I don't think it's necessarily. We don't need to go to that kind of extreme, and it actually could come back and bite you in the behind in a jury
if you
trial.
don't find
you don't want to have too much of a technical kind of defense where it shows, hey, the jury's going to think, hey, he threw all that money at this defense. He really must be guilty. So I think this approach is actually a more appropriate approach, which is simply saying this, just like Janet had just said, this is the story that my client has given me, and this is what has transpired, and okay, prosecution, what do you have?
I'll tell you
what's
though.
really good is a shoddy investigation. They don't have a whole lot with respect to these footprints. There isn't a great smoking gun here.
If you want to convince me, though, if you would have raised a reasonable doubt with me, believe it or not, if you were able to a bottle of whatever and swab it and find his DNA at the scene. My goodness, that would be huge. But
Vinnie,
let's
couldn't you argue? I'm sorry, Vinnie, couldn't you argue, look, we didn't have an obligation to do that. The state has an obligation to investigate that. They didn't go to the man cave. They didn't bring you the DNA. You can't look to us for DNA. You have to look to the state. That's reasonable doubt. That's a lack of
Goodman would have to tell him about the man cave. Why would we go look at the man cave unless Goodman told us? And he has a right to remain silent, which I'm sure he, to a certain extent, would exercise. All right. Charles Mittelstadt, great job. Great to have you here, pal. All right.